Since it's first thing in the morning, I have made this quite entertaining. This later on in my presentation is called the Sex and Swastikas presentation for reasons that will become glaringly apparent. However, I've got to talk about some law first of all. Well, the rest is law, but it's amusing law. But I really need to go through some basic principles about intellectual property. And just touching on what Chris said, it's not here in the slides, but the creative industries contribute a massive amount of money to the UK's economy these days. And I know that you're all involved in it, but do not underestimate how much we are reliant on your output as creators to fuel GDP for the UK. It's estimated that something like, in the USA, they estimate something like 80% of a company's value now rests in the intangible assets. And those intangible assets are things like patents, copyrights, trademarks, know-how, the way of doing things, data, all that kind of thing. And for anybody who's involved in the creative industries, just to put this into context, we are absolutely world leaders when it comes to certain elements of creativity, whether it is computer software and games, whether it is digital media, whether it is broadcasting, whether it is cyber security. All those things are really important to us as a nation. Excuse me. And I was very heartened yesterday to see in the budget that there's some acknowledgement of that and the investment in the creative industries and R&D and technology generally, and stimulation for growth of the creative industries. So what am I going to talk about today? Well, basically what I'm going to talk about, I mean, in general terms it's intellectual property, but I'm really going to focus here on trademarks, because trademarks are brands and they're absolutely fundamental probably to anything that you do. And just to talk about the boring bits really to start with, what is a trademark? Well, a trademark is defined as being something that identifies a company or a brand. It's something that brings in business. It's the goodwill that is attached to a name or a logo or an identity of some kind. And the first and early trademarks were things like, for example, brands on China. You may have seen the original kind of Wedgwood logos and trademarks and things on China. And also, if you go around locally and you look at things like cotton that was imported into Lancashire, it all had the originator's name on. So trademarks have been around for donkey's years. And in 1874, we had the first Trademark Act. And the very first registration for a trademark was the Bass Red Triangle. That's the number one on the trademark registry. And it's still there. And it is still valid. It is still renewed. And all of you will recognise that instantaneously. So what can be filed as a trademark? Well, we've got Virtuoso, in actual fact, is filed for legal services, not surprisingly. We've also got, we haven't filed this as a trademark, but I just put it up just to illustrate what we could file. There's two elements there. We could file a Pantone colour of that colour blue that we use, and we could also file a trademark for our logo mark. We don't actually have registrations for either of those, but we could do. And colour marks are really, really useful if you think about it. If you're creating a global brand identity and you want to be instantly recognised, then a colour mark is quite a good idea, because people don't always recognise a word mark. If you're in China or you're in Taiwan, somewhere like that, you won't recognise a word mark, but you may well recognise a particular colour. And some big international companies have got colours registered. BP have got that green registered, all oil products. And in fact, if you look at their get-up and what they do from a branding perspective, it's all in that Pantone of green. Their fuel stations are all done in that Pantone of green. Same with Cadbury. Again, the purple is readily recognisable as being a chocolate brand. And there's one or two lesser well-known ones. Whiskers have got the purple Pantone, very similar in fact to Cadbury's one, that's registered as a trademark. Again, you can have logo marks, which again are very useful for international trade, because it means that with international, with people who don't speak English, they'll readily recognise something that's the Nike tick or the Adidas 3 stripes. And again, the big brand owners routinely register those kind of things as logo marks. I haven't put it on here, but there's other things you can register as marks. For example, you can register sounds as marks, as trademarks. And again, back to creative side of it, you know, the direct line jingle, that little telephone. That telephone, incidentally, is registered as a trademark, as is the jingle, because that is distinctive of direct line. You can also register smells, although it has to be said there are very few smells that are registered on the trademark registry. And what you have to do if you want to register something unusual like that, a shape or a logo, or well, not a logo, but a shape or a piece of music, or indeed a smell, you have to be able to describe it. So that's the difficult part, really, particularly with smells. So let's have a look at filing your trademark and what you can file your trademark in. Now, there's 45 different classes of trademark. So it covers everything from class 1 and class 3, which might be soaps and chemicals, through to class 9, which is software, class 25, which is clothing, class 44, which is legal services. So there's a whole range of classes. And one of the things that I'm quite commonly asked is, well, so-and-so is using Virtuoso. For example, we've got a Virtuoso van that is near me in Leeds. Makes me smile every time I see him because he's got virtually the identical logo to me. However, this man is a plasterer, he's not a lawyer. So he's really not trading in my arena or stamping on my feet in any way, shape or form. And that's something that a lot of people don't understand. They think, well, I've got a registered trademark. But if your registered trademark is in, say, class 25, and somebody is producing soap with your trademark on, then it's unlikely to be a trademark infringement. The exception might be that you have what we call a very famous mark. So obviously if you're Coca-Cola and you're sticking that on different things, then you could well run into problems. Where it's a really, really famous mark, there are issues there. But for the vast majority of trademarks, it depends on the specification that you've got filed. And the specification is something that is quite important these days when you're filing. We often talk to brand owners about, okay, well, it's not just what you're doing today that needs filing, it's what you might be doing 3 or 4 or 5 years down the road. So say, for example, they are registering in computer games or clothing. They may want to extend the brand to jewellery, they may want to extend the brand to online services, whatever it is. And we talk to people about not just the immediate need to trademark something, but what they're going to be doing within the next 5 years. And that's key. That will save them quite a lot of money, because if you file again, then you've more filing fees to pay and so on and so forth. As a firm, we do UK and European filings. We also do some globally. But the key thing to remember with any trademark is you do not have protection unless you've got a registered mark in a particular country. Intellectual property, whether it's trademarks, whether it's patents, whether it's registered designs, you have to have a local registration. So for anybody who is, say, manufacturing in Taiwan or China or wherever, they routinely register those trademarks, basically to stop product from going out the back door and being with their label on. It's not an infringement in China unless it's registered. So that's very, very important. I put the R in a symbol up here because, again, once you've got a registered trademark, that's the sign that you should be using next to your registered trademark. It denotes that you've got a registration. C in a circle denotes that you're claiming copyright in something. So I was having a chat with this lady here about copyright material. If you are presenting copyright material to people and you're doing it as part of a pitch document, which I'm sure you all do, make sure you've got your C in your circle next to it, and you know, Liz Ward 2016, whatever it is, because that's really important. It denotes that you're asserting copyright in it. The other thing too, a bit of an elephant trap that a lot of designers and creative people fall into, is presenting concepts and presenting ideas to people without the benefit of some kind of protective contract, like a non-disclosure arrangement. If you're going to pitch for something, for goodness sake, make sure that somebody doesn't go off with your brilliant ideas and try and get them to sign up to a confidentiality agreement that says basically what I'm presenting to you is confidential, and also what I'm presenting to you is my copyright. You're not entitled to use it without this discussion going a little bit further. It's not always that straightforward if you're a small entity, you're dealing with bigger clients, but for goodness sake, try and do it, because if you don't, it gets much more difficult to enforce. Okay, a bit more entertaining now. Some of the things that aren't allowed. Now, this is quite often where we get the phone call because people have come up with a really great idea, but their really great idea is a trademark for office cleaning services for office cleaning services. Well, guess what? You're not allowed to do that. It's completely descriptive of what you do. And whilst in some circumstances we can get around the trademark legislation by making something stylised or doing it in a fancy font face or putting it into a logo type style, plain descriptive words, which are the broadest kind of cover that you can get, if it's completely descriptive of what you're doing, then I'm afraid you can't register it. Slogans is another one that people often think, well, slogan, every little helps, Tesco's. Those can be very difficult to register, and that's for public policy reasons, because basically the trademark registry is not there to hedge in and to ring fence parts of the English language just so that you can use them as branding. Again, there are ways around it, and if you talk to us, sometimes we can get those kind of marks registered as trademarks because they've become distinctive of you, or because you've got really long usage and it's used in a particular way. We can sometimes overcome those arguments from the trademark registry. Some names are not allowed to be registered. If your name is Fred Smith, it's going to be very difficult to get a trademark registered. Now, of course, there are lots of very famous people who have registered their trademark. David Beckham is a classic case in point. No, I haven't looked at Wayne Rooney's, but I have no doubt that Wayne Rooney has a trademark registered for his name. And they will cover those key trademarks so that they can then put David Beckham onto sunglasses, onto clothing, onto whatever it is that they are producing, either endorsing a line or indeed manufacturing their own, because there's two ways really that you might want to endorse things as a famous person. Footballers, of course, Sir Alex Ferguson has got his name is trademarked. Mourinho's name was trademarked, and rather famously, globally trademarked and owned by Chelsea. So he had some difficulties when he came to Manchester United in respect of that. Laudatory terms are not allowed. Number one holidays, first choice, best in class, whatever. Again, you've got to be very careful with those kind of trademarks. Again, sometimes after a period of use, you can demonstrate usage to the trademark registry and you can say, everybody knows us as first choice holidays, we're entitled to a trademark now. But you're not going to get one from the get-go. And the last thing to mention on here is marks that are confusingly similar to earlier trademarks. The one thing that I would say all of you must do if you are looking at registering a trademark is get a professional search done. When we do clearance searches for trademarks, what we do is we do kind of a landscaping exercise. So we look at who's got what. We got a trademark in the other day, and there was two elements to it that we had to look at, and we searched against both elements. When you do a lot of, or for the cheap and cheerful searches that some people offer, or indeed the Trademark Office themselves offer, what they're looking at is only the dominant element of the trademark. They're not looking at the whole landscape. They're not looking at what is confusingly similar. And when we do it, we do a much broader exercise to look at things that aren't just identical, but things are phonetically similar, things that are confusingly similar in some way. And we also try and assess the litigation risk of doing something. I had a lady on the telephone actually only, what day are we today? Thursday. I think she called me on Tuesday because she had attempted to register Bike HQ, and Halfords had written to her. They got Halfords Bike Hut. Now there were a lot of reasons that she could probably have opposed their opposition at the Trademark Registry. She hadn't done a clearance search first, and she'd filed it herself. But as I pointed out to her, regardless of the merits of her application, she was never going to win against Halfords, because she was a small bike accessories retailer, and Halfords have got very deep pockets and are going to defend it to the end. So okay, it's only £5,000 to, in our fees, say for example, to go through the Trademark Register and file all those arguments. But if she loses, not only has she paid us £5,000, she's going to have to pay £5,000 to Halfords. And by the way, Halfords are commercially huge. We know that the litigation risk with somebody like Halfords is significant. Now, had she done a clearance search, that would have been flagged up early on, and we could have given her an assessment of the merits at that point, and possibly even agreed some kind of coexistence agreement. Once you've slammed your trademark application in, if you then have to withdraw it, you've lost your filing fees. So in the UK, you might only be losing a couple of £100 in official fees, plus your legal fees, of course. But in the EU, your official fees start at £700–800. So it's quite a lot of money really to lose for the sake of a £300 clearance search. Right, we're on to sex and swastikas now. We're on to the raunchy, riotous bit. Other things that the Trademark Office do not let you register are things that they consider are contrary to public policy or accepted principles of morality. And you see that legislation also with the Patents Act. The Patents Act won't let certain things, for example, be registered. There's quite a lot of controversy when it comes to, under patents, whether or not you can patent a mouse that grows an ear on its side, because again, is that against public policy? And there are long debates about that. You see this public policy argument used in some copyright matters as to whether or not it's something is offensive and whether or not it should be published. But you also see it in the Trademarks Registry. And increasingly now, because moral tastes have changed slightly and because people are using different language for trademarks, there's a lot more cases coming out, and I'm going to illustrate some of those. The classic one here is the swastika. Now, I didn't know this until yesterday, but my assistant, Lakmal, who's Buddhist, told me that that is the reverse of the Buddhist symbol for love and peace. And apparently Hitler chose a mirror image of that as his symbol, which I thought was really quite weird. But obviously with a logo like that, you are not going to, it's so well recognised, you're not going to get a logo like that registered at the Trademark Registry. So let's have a look at some of the other things that the Trademark Registry are turning down. Hallelujah. Again, they do not like religious references, and for the similar reason that they've turned down Jesus and they've turned down Muhammad, because again, those sort of, may be deemed to offend Christians, and even used in a slogan mark, they can be difficult to, or more than that, they can be virtually impossible to get registered. Umphys, which apparently is a sort of a sexual connotation in the States. That's registered in class 25, that got through, although it's now no longer on the register because its time expired. Joe Turd's Turd World got through. Yeah, and that is that's a gaming classification, and that, if you like, shows the attitudes of younger people towards what more mature audience would say is quite offensive. I mean, turd isn't a very nice expression, is it? There was one or two other I looked up on the register yesterday. Shitbox, that didn't get through. So you can be sort of offensive, and you can make various sexual connotations, but don't get religious, and yeah, you could well be sort of in the firing line. Yeah, so the turds, goodness knows. FCUK was refused. Screw you was allowed. And it was registered first in class 10 for condoms. And then, not surprisingly, and not deemed descriptive either. Class 25, obviously, if you're a fan of that kind of clothing, you can wear a t-shirt with "Screw you" on. Bin Laden was refused, not surprisingly. Hitler has also been refused. And the last one, "Fuck, calm, die in battle and go to Valhalla," was also refused. Now,
can I ask a question?
Yeah, sure.
When you say Bin Laden was refused, I know it's obviously based on religion and stuff, but Bin Laden's obviously a construction company in the Middle East, so how would that work on something like that?
Well, it might be.
Because his family do own one of the biggest construction companies in the Middle East, so if they did that for their particular business, I wonder how that would...
Well, they'd probably be okay in the Middle East. I don't know that they get a registration in the UK. And would you call your company Bin Laden if you came to the UK or the States to do construction work? I think the answer to that has to be no. Because because it's so well known. Maybe, you see, what you forget about some of these is that in 20 years' time, it will be completely different. And things that are allowed onto the registry now would have been turned down 20 years ago. And in 20 years' time, they will be accepted in modern parlance. I mean, think of what the BBC used to censor and used to cut out, and what they don't cut out now, because it's just not as offensive as it used to be. And you don't have Mary Whitehouse either, sort of publicising and making a big issue of a lot of these things. This is quite an interesting one. FCUK, which of course is French Connection, a UK, and that was registered. It's been registered in class 25 for clothing since about 1996. But again, some member of the public decided that was actually an offensive registration and took an application to court to invalidate the mark. And it wasn't just the FCUK that they objected to, it was the FCUK at home, Oda FCUK, and these other ones, which I won't pronounce. This one, somebody tried to register it as King Canute, and made some other reference to it, and that was also refused. So you have to be a little bit careful when you're doing registrations. His Honour Justice Ratty, who examined the application to invalidate the trademark, did not like the words FCUK, and had he been an examiner, who luckily was a High Court judge, and he didn't overturn the examiner's decision, but had he been a trademark examiner, they would not have got a registration back in 1996. So whilst we laugh about that, and we probably don't find it offensive, some people do, and you've got to be aware of that. Beware of brand meanings overseas too. This is another classic one, and again when we do a sort of a clearance search, particularly for bigger brands and global brands, we have a look at what the translated meanings are, and there's some absolute corkers here. Nova, of course, you'll remember the Nova. Well, Spanish it meant no go. Not a great name for a car. Apparently the Chinese symbol for turtle is deeply offensive in China. And the Chinese translation of turtle comes out as something along the lines of motherfucker. And motherfucker is one that people, again, that's sort of right on the margins there of what it can and can't be registered. But you wouldn't do that if you were going to trade in China with that mark. You would avoid it. And again, these are the sort of things that sometimes flush out in a trademark clearance search. But there again, who hasn't wanted some shit lemonade? And that again just goes to show, you know, marks that shit is really popular on the continent, incidentally. Yeah.
Get it in Joe Ted's third world.
Yeah, you probably can. You probably can. Right, let's have a gamble through some comparative advertising now. I like comparative advertising. It always makes me laugh, and it is a great way to stand out. And you know, you see lots of comparative advertising. EE mobile contracts are cheaper than Vodafone contracts. So it is a good way, and particularly if you're representing the newcomer to branding and marketing and you're up against some big players, why not say that you're better value than blah, blah, blah. However, again, you need to stay the right side of the law if you're going to do it. So here's just a few pointers about what you do need to be aware of. If you're going to use trademarks, if you're going to use somebody else's trademark on your website, on your branding, on your advertising generally, it's got to be a fair and comparative advert. So you can't say, for example, that this glue is stronger than that glue when you've used a glue that's used in a completely different sense. Again, this was a case that we had this week. A client had come in and they got a flyer that they'd been distributing around DIY stores and so on. And it was X brand of glue was better than Y brand of glue. And there was a complaint made that it wasn't a comparison, it wasn't a fair comparison because they were gluing different things. I have to tell you, looking at the flyer, it wasn't immediately obvious that they were gluing different things, but there was a complaint there, which, you know, we didn't really need to. We withdrew our trademark or the other side's trademark from the branding. It wasn't a big issue, but do be careful that it is an absolutely comparative situation that you are looking at. And beware of the fact that there's basically two pieces of legislation you need to be aware of. There's the Trademark Act, which permits pretty much all comparative advertising, provided it fits the fair, comparative and verifiable rules at the top, and doesn't, what the legislation says, make an unfair advantage of comparison. Thanks, Chris. The judges recognise that when you compare one thing against another, that there's a certain element of what they call puffery in the advertisement. The Advertising Standards Authority tend to be a little bit more pedantic about it being a fair comparison. And okay, that's not going to get, it's only going to get you a slap on the wrist or a fine or whatever. But do be aware of the fact that the Advertising Standards Authority do have regulations about what is or is not permissible. And if you start to use it, I'm going to go through some examples now, can work really, really well, and it can backfire. Morrison's did a fantastic, price compare advertising campaign, and they did it against Lidl. I think Lidl's response was absolute genius. I don't know if you can see that. How you actually go and find a comparable way to match Lidl's prices is they have to do all those things, which of course you probably do have to do to get this card for a price match comparison, or you could just go to Lidl. Now, I thought that was quite genius, actually. I rather like that. Let's have a look at some other things that have tickled my funny bone. Use must be fair. Do you remember that scandal a few years ago where Ryanair, who were flying all over, were flying about 50 miles from where you wanted to be? I think there was they flew to Rome, didn't they? But they flew to an airport that was like 50 miles from Rome. And again, that sort of comparison works really, really well, comparing one with another. And both trademarks are used in that. I must admit, I'm not a big fan of Ryanair, so that really kind of amused me. But the real geniuses in all this are definitely Aldi and Lidl. Because we remember this lady, don't we? Because what I remember about her is she drinks gin. And she buys her husband tea bags, and he can't tell one set of PG tips from Aldi's own brand tea bags, but clearly she can tell one type of gin from another. And here they have comparing champagne from Aldi, and again we've got the Aldi trademark there and the Moe trademark there. I bet Moe were livid when they saw that. There you go. And again, to make it fit in with the legislation, they've tested people. 229 like Moe, 86% of them also like Aldi. So there's no complaint there that there hasn't been a fair kind of comparison. And also checked the prices. So again, they've checked the prices. They said on the 1st of February 2013, that was what Moe cost on the Tesco site. And let's face it, who's going to challenge that? Because Tesco are big, they're a discount store. And then the details at Aldi.
Is there a minimum threshold? So like where they say in the test 229 people liked it? Is there
no, there's no absolute there. It's just kind of got to be some kind of comparison that's done. So people can say that that's not grossly unfair, and that you've chosen it from, you bought it from a high-end retailer. You haven't bought that from Harvey Nicks. Yeah. You've bought it from Tesco's, and you've let people drink it, and 86% of them probably couldn't tell the difference.
So you couldn't say, we asked Steve and he said Aldi was better. It has to have a fairly serious number.
It's got to kind of be vaguely fair.
Yeah.
But as you can see, they've not gone to a massive effort there, have they? I mean, God knows whether or not those figures are actually true. But I mean, they will have price checked it. They definitely will have price checked it.
No one could check that either, can they, really?
Well, if there was a complaint at the Advertising Standards Authority, the ASA would say, what checks have you done? And you'd say, oh, well, we have this focus group and we made them all drink Aldi champagne and Moe, and this is the finding. So they might do, but they haven't. That's not taken a massive effort, has it?
No.
If you're referencing another trademark, do you not have to include the symbol?
No, you never have to include the symbol. It's just best if you do it on your branding.
Is that more of a warning to other people? Rather than
it is. It denotes, and you sometimes see in America they use TM in a circle next to it, but it's got no legal meaning. R in a circle over here means it's a registered trademark, and in fact, if you put an R in a circle next to a mark over here that is not registered, it's actually a criminal offence because it's designed to stop counterfeiting. And some people, what they do is, whilst their trademark is being registered, they'll put a TM next to it. But it's a bit of an Americanism. It doesn't actually mean anything. The R in a circle does.
The comparisons only come in like 10, 15 years ago, I remember. You're allowed to do it in advertising, because up until then you weren't allowed it.
No, certainly the 1994 Trademark Act put it into legislation. Section 10.6 of the Act deals with comparative advertising, and the key thing there is it says, the legislation says the comparative advertising must not make
false
assumptions.
No, it says something like take unfair advantage of the other brand, and the way that that's interpreted in the law is making it a fair comparison.
What's the rules around what brand mark you're supposed to use? Like, say you've got Moe there. Could you put that in any colour you wanted? Is there any sort of legislation with regards to that?
No, you're not obliged to use it.
So you could just write the word Moe if you wanted to. You could use
absolutely, yeah.
They've been quite clever to put more bottles on there.
I think it. I love that. Aldi don't have it all their own way. This is bargain booze. Aldi schmaldi. And that's quite good too, because obviously what they've done is they've taken the Aldi brands and compared them against labels that people will find desirable, apparently. Carlsberg Export and Schmoonoff. So again, Aldi can't stop them from doing that. And in a way, I think this is the great opportunity is for a lot of the retailers who are at that end that lower end of the market where they are comparing home brand versus labelled stuff. There's a lot of scope for them to do this. And generally speaking now, the big labels don't really object.